India has a new data protection law, Digital Personal Data Protection Act 2023. If your business collects customer names, phone numbers, emails, or any information that can identify a person, this law applies to you directly, and it creates binding legal obligations on how that data is collected, stored, used, and deleted. First question is what counts as personal data. The Act defines it as any data about an individual who can be identified from that data. In practice, it includes name, mobile number, email address, Aadhaar number, PAN, IP address, location data, biometric data, device identifiers, and purchase history. Understanding three concepts will make every other obligation make sense. First, personal data. Any information that can identify a living individual. Second, the data fiduciary. Any entity that decides why and how personal data is collected, and that classification triggers your legal obligations. Third, the data principal. This is your customer, your employee, your app user. They are the individual whose data you hold. So, does DPDP Act apply to your business? For almost every business watching this, if you run an e-commerce store, if you use HR system with employee records, if you have app with Indian users, if you manage a B2B or B2C customer database, the Act applies to you. The physical location of your business is not a determining factor. Every obligation in the DPDP Act flows from three principles. 1. Consent. Before you collect personal data, you must ask. 2. Purpose. You may only use the data for the reason you collected it. Using customer delivery data for marketing campaigns, for example, requires separate consent. 3. Rights. Individuals have the right to access data, correct it, and ask you to erase it. They are legal obligations. In August 2023, Parliament passed the Digital Personal Data Protection Act. To understand how significant this change is, compare the two frameworks. Under the DPDP Act 2023, consent is mandatory before collection. Individuals hold 5 defined rights. The Data Protection Board serves as the regulator, and the maximum penalty is 250 crore rupees. Answer 3 questions to confirm whether the DPDP Act applies to your business. 1. Does your business collect personal data of Indian citizens in any digital form? 2. Does your business decide why that data is collected? 3. Do you offer goods or services to individuals in India? If answer is yes, regardless of where your business is registered, the Act applies. 3 takeaways from this video. 1. The DPDP Act 2023 applies to any business processing personal data of Indian citizens. The physical location of your business does not change that. 2. If your business decides why data is collected, you are a data fiduciary. 3. 3 principles govern all obligations: consent, purpose limitation, and individual rights. The next video in the series covers why India needed this legislation and why that legislative context matters for how your business should approach compliance.